Welcome back, aspiring solicitors. Welcome to SQE1 window. I hope your journey in contract law is going all good. And I hope we are making sense of content that we have discussed in our contract law sessions. So today we are entering the land of vitiating factors, the legal gremlins that creep in and destroy otherwise valid contracts. In simple terms, vitiating factors do not say there was a contract. Instead, they say there was a contract, but something about how it was made is fishy. So, fishy and vitiating, but keep in mind so it will resonate. So, these factors deal with defective consent, for example, time when one party said yes, but only because they were deceived, mistaken, pressured, or manipulated at some point. So we need to understand that how these fishy things impact the contract. There are four key villains in today's drama. Misrepresentation, when one party lies or is careless with the truth. Mistake, when everyone gets it wrong. Duress, when someone is forced into the deal. Undue influence, when persuasion crosses the line into exploitation. So let's unpack each one, starting with the lawyer's favorite of dishonesty, or we call it misrepresentation. Misrepresentation occurs when one party makes a false statement of fact or law that induces the other to enter the contract. The key elements are the false statement of fact or law, not opinion or sale puff, unless made dishonestly. It must be made by or on behalf of the other contracting party. It must have induced the claimant to enter the agreement, and that's very important to understand. Inducement to the agreement. Silence is not usually enough unless something changes the party fails to update the other. In with case, like I would say it, a doctor selling his practice truthfully said it was profitable, but then lost all his patients before completion. He stayed quiet. The court said the silence amounted to representation. When circumstances change, you must speak up. You must tell other party about change in circumstances at that point. If you don't, even silence can become misrepresentation. Even opinions can count if given dishonestly. In Smith versus Landhouse property case, a landlord described a tenant as most desirable when he knew the man was behind on rent. The court said that was not optimism, it was deception dressed as politeness. So in that case, the person who makes a statement will be responsible. Of course, like a tenant who is behind on rent is not at all desirable. So there are different types of misrepresentation. And we will try to talk about three main types. First is fraudulent misrepresentation, defined in Derry's case, made knowingly false without belief in its truth or recklessly. That is legal version of I just said it to close the deal. The remedy, rescission, cancelling the contract, and damages in tort, all losses, even unenforceable ones. Second is negligent misrepresentation, bit mild. In Hadley case, so that's defined in Hadley case and Misrepresentation Act 1967, Section 2(1), that is made carelessly without reasonable grounds of belief. What is the remedy if it is? If it is negligent misrepresentation, rescission plus damages, as if it was fraudulent, unless the person proves they had reasonable belief. They were not that negligent in that case. Third is innocent misrepresentation. When the person honestly believed the statement to be true, remedy is Receiving or damages instead if the court thinks that is fair. Like, if court thinks that's fair, no damages, no Receiving. Remember, misrepresentation makes the contract voidable, not void. Mean the contract exists, but at the option of party that is suffering because of that misrepresentation. It exists until the innocent party decides to set it aside. Another thing is remedies. We need to talk about remedies and limits for misrepresentation. So let's talk about remedies. The main one is Receiving. Setting the contract aside and putting both parties back to where they were before. It sounds simple, but being lawyers, there are several ways to lose it. You lose Receiving if you affirm the contract, you agree to it after discovering the truth. Restoring parties to their original position is impossible. You can't take them back. Third party has acquired rights in good faith. There was something going on, but a third party also acquired some rights in it. Too much time has passed. It has been long. If Receiving is not available, you can still claim damages. For fraud, all direct losses are recoverable. For negligence, under Section 2, Section 1, damages are the same as for fraud. For innocent misrepresentation, only if the contract orders, only if the court orders, like at that point, or contract allows, say, to just go for Receiving or cancellation of contract. So the worse the conduct, the more generous the remedy. Fraudulent pay dearly. Honest fools get leniency, like if they were that fool, that not careful while doing contracts. So another thing is mistake. I'll try to have an overview and types of it. So when both sides simply got it wrong, unlike misrepresentation, there is no dishonesty here. Just a mutual misunderstanding of reality at that point. There are three types of mistake. Common mistake, both parties share the same mistake or mistaken belief. That was Bell case. Like mutual mistake, they are talking about different things entirely. One is talking about one subject matter, and another is talking about another. The two ships named Peerless. In that case, one was talking about one ship and another was talking about other. Unilateral mistake. One party is mistaken and the other knows or ought to know that they are mistaken. Seller quoted price per pound instead of per piece at that point. So if the mistake is fundamental to the contract, for example, in that case of ship, the contract is void, meaning it never existed. That is different from misrepresentation, which makes it voidable. So keep in mind, in case of mistake, the contract goes void. So common mistake in practice. Let's just dig into it because you will find some questions from mistake, hopefully. Fingers crossed. And I wish you all the best in understanding what we are learning today. So now, do not get too excited. Common mistake almost never works as a defense. Court use it sparingly because contract needs certainty. In Bell's case, a company paid generous compensation to executives, unaware that they could have fired them for breach. The court said the mistake was not fundamental enough at that point. The only time common mistake works is when the error destroys the contract's purpose, for example, when the subject matter does not exist. In Courtier case, both parties thought they were selling corn on a ship, but the corn had already been sold elsewhere. The contract was void. There was literally nothing to sell, and they were mistaken. For a while, equity tried to soften this harshness in Soul versus Butcher, allowing Receiving for equitable mistake. But that generosity ended with the Great Peace 2002, which reasserted Bell. The modern law is clear. If you want out of a contract for mistake, good luck. You will need it. So, so at that point, you need to understand, you need to look at like where contract goes void and goes to the root of that contract. Another thing that is fishy, that can go fishy, is duress, illegitimate pressure. Now, from confusion that we had in term of like, mistake, we are going to coercion or duress. Duress arises when a contract is entered under illegitimate pressure, leaving the victim with no practical choice. There are three types: duress to the person, threat of violence, for example; duress to goods, threat to seize or damage property; economic duress, threat of financial harm, such as refusing to perform unless terms are changed. So we got different cases where small companies agreed to new terms under pressure of financial ruin. Like, there was threat that if you don't agree, we will bash you in terms of economics, finances. The court found duress. The consent was not genuine in that case. Remember, a contract must be with free consent, and duress makes it fishy. The test from Universe case asks, was the pressure illegitimate? Did it coerce the victim's will? Did it impact it or not? If yes, the contract is voidable, not void as it was in the mistake. The remedy is rescission. So in short, if the agreement looks more like sign this or else, it is probably not an agreement at all at that point, and the party can avoid obligation under a contract that was signed in result of duress. So another thing is undue influence, another fishy thing in contract. Finally, we have undue influence, where persuasion becomes manipulation. It involves one party taking advantage of a relationship of trust to obtain consent unfairly. Two types exist: actual undue influence, where direct coercion is proven, William versus Bailey case; presumed undue influence, where the relationship itself gives. That was active, actual undue influence, and this one is presumed undue influence is passive, where the relationship itself gives rise to suspicion, such as between parent and child, solicitor and client, or doctor and patient. So never enter into agreement with your client. So be careful with that. Like, you can be victim of undue influence at that point. So the leading case is Royal Bank of Scotland versus Entrade. This confirmed that if a transaction looks suspicious, for example, a wife guaranteeing her husband's business debt, the law presumes undue influence unless she had independent legal advice. That's why once you will be entering into mortgage, your bank will ask your wife to sign an independent declaration. The contract is voidable, and equity steps in to protect genuine consent without penalizing honest persuasion. So remember, law loves fairness, but it hates manipulation in language of trust. Of course, careful. Once you become solicitors, try not to enter in business or commercial relationship with your clients. So our favorite SQE tips and common faults, like pitfalls that we got, like always identify which vitiating factor applies. Is it misrepresentation, mistake, duress, or undue influence? Don't confuse them. Remember the difference between void and voidable. Mistake makes it void. The others make it voidable. Take it or leave it. Include remedies: rescission, damages, or both. And you can find it from the cases we have discussed: Derry's case, Bell, Atlas, Entrade, all of them. So just keep in mind. You will not be tested, hopefully, but just keep in mind. So discuss limits, affirmation, lapse of time, third-party rights. At that point, it is something external which can keep the contract as exclusions. So pitfalls, we got it: confusing mistake with representation and saying that this is void. Deception is key for the later, for misrepresentation if it is deception. Forgetting that economic duress must involve illegitimate pressure, not just hard bargaining, not at all. So companies can bargain and they can bargain very hard, but they cannot threaten other with consequences. Treating void and voidable as the same thing, they are legally worlds apart. Overlooking independent advice in undue influences cases. So if it is independent legal advice, so at that point it will save the person who got relationship of trust. If you structure your answer at that point and you understand it in MCQs, so it will make your life easy. And if some corner is left or you think that it did not make sense, go back to our discussion. It will. And I tell you, you are learning mother of all private laws, that is contract law. I wish you all the best. Ta-da.